Speaker is Shri H.S. Bhangoo. Mr. H.S. Bhangoo needs no introduction. He has been the face of the Academy for over a decade. Mr. Bhangoo joined Superior Judicial Services in Haryana in the year 1995, and after an illustrious career spanning over more than a decade, he retired as District and Sessions Judge on 30th April 2011. Shri Bhangoo joined as faculty member on 14th November 2011. May I request Shri H.S. Bhangoo to enlighten us on the topic of bail legal scenario. Over to Mr. Bhangoo.
Thank you, Madhu. All right. Yeah.
Sir, good afternoon, sir. Sir, I am going to ask you certain questions and would like sir to please enlighten us on these issues. Sir, my first question to you is, the investigation in a criminal case was completed without arresting the accused, and the charge sheet was filed in the court without arresting the accused. Can the magistrate take the view that as per section 170 CRPC, when the charge sheet is filed in the court, the accused are required to be forwarded under custody, otherwise the charge sheet would not be taken on record?
This misconception has been there. Some of the judicial officers, they still have this misconception that the accused has to be produced in custody when the challan is filed. And sometimes they even refuse to accept the challan, which is absolutely not permitted by law. And the Supreme Court has said it in so many words and so many times that you can't refuse to accept the challan once it is filed. You may pass any order on it, but you can't say that unless the accused is brought in custody before me, I will not accept this challan. No, that is not permitted. And moreover, there in the recent judgment of Siddharth versus State of Uttar Pradesh, it was Live Law 2021, Supreme Court 391, wherein the Supreme Court has again clarified that the accused is not required to be produced in custody when the challan is filed. So this thing should be very clear to all the officers. It should be very clear.
Right, sir. So next question is, so please elaborate on Arnesh Kumar judgment of the Apex Court. Do we have any recent judgment of the Honorable Supreme Court on Section 41 and Section 41A CRPC?
Yes, Arnesh Kumar judgment. Most of the officers they are aware of this judgment now. By now, it is a landmark judgment, no doubt, and it has emphasized and it has explained what is Section 40, 41 and 41A, etc. Whenever an accused is to be arrested, this judgment explains to us that merely because there is the power is there for arrest doesn't mean that you have to arrest the accused. Rather, Section 41 itself explains that for offences punishable up to 7 years, 2 elements have to be fulfilled. Firstly, the concerned investigating officer, he should have reasons to believe that a cognizable offence has been committed by the concerned accused. First, he should have that reasons to believe, and secondly, he has to record his satisfaction that arrest of the accused is required, and the arrest can be made on any of the grounds which are given in subclauses A to E.
Right.
Subclauses A to E of Section 41, Clause 1. So, and it has to be followed in letter and spirit. The Supreme Court says any ipsy dixie excuse or just coming forward with the explanation that it's a very grave offense and so we need his custody. So that will not do. They have to come forward with materials on the file to satisfy the concerned magistrate that actually his custody is required, that he has to be arrested. And what are those grounds? The grounds can be he may be an habitual offender who, if not taken into custody, he may commit the offence again. There may be chances of absconding. It may be one of those cases. So those grounds which are given in 41, on any of those grounds he can be arrested, but it has to be there in the record, in the report which he produces. He has to produce the material also. If he is an habitual offender, then he has to tell in which cases he has already been convicted by the courts. So that material has to be produced before the court, and the court has then to pass an order that yes, I have gone through all this, the material which has been produced by the IO, and I am satisfied that he has complied with the instructions which have been given in the judgment of Ramesh Kumar. That satisfaction has to be recorded by the concerned officer also. And if the judicial officer does not do his duty, departmental action can be taken against him. And if the police officer does not perform his duty, departmental action can also be taken and contempt proceedings can also be initiated against him. So it's a remarkable judgment, and it has again been followed by the Supreme Court in recent case of Satendra Kumar versus CBI. Satendra Kumar versus CBI. The citation is Live Law 2022, Supreme Court, page 577. So I hope that answers the question.
Yes, sir. So next question is, are there any other important points which are laid down in the said judgment of Satendra Kumar?
Yes. Satendra, it's a very important judgment. And the Supreme Court has also said in the same judgment that this should be included in the curriculum of the judicial academies also. That judgment. So it not only explains the provisions of section 41 and 41A, etc., and reiterates what Supreme Court had said in the case of Ramesh Kumar, it further also emphasizes the importance of 436A and 440. People who are in jails for a considerable period of time, directions have been given that the High Court has to go to revise or go visit the jails and check up whether any person who should have been released under 436A is not there in the jail, or any person who could not comply with any stringent conditions imposed by the concerned magistrate. Necessary rectifications have to be done so that such person can be released from the custody. This was also there. Then they have also explained that what is the difference between bail which is granted at the appellate stage and the one granted by the magistrate, 389 and 437. What is the difference between the two? That has also been explained. And the same judgment also lays down that that any application for bail has to be disposed of within a period of 2 weeks. Most of the officers are following that already. So, and it has also again reiterated the law which was laid down in the full bench judgment of Rakesh Paul and other judgments pertaining to 167 CRPC also regarding default bail. That has also been explained in detail. So there are various aspects.
So you just talked about default bail. So we have this provision under section 167 CRPC. So sir, I would like to ask that whether it is incumbent upon the court to communicate to the accused about accrual of right to default bail after expiry of the statutory period of detention.
Yes, it is obligatory. Now this has been so held in the judgment of Rakesh Paul, a 3-judges bench. Both Justice Loku and Justice Deepak Gupta, they had emphasized on this point that it is the duty of the court that they should inform the accused that you are not now entitled to default.
So next question is, what happens in a scenario where application for furnishing bail bonds is contemporaneous to the filing of challan?
Yes, we have that problem many times. The accused, he comes forward with an application that he is entitled to default bail. There is a period of 60 days or 90 days has also expired. And the moment he files that application, the charge sheet is also filed, because mostly the Nair court, he is present in the court, and when he learns, he immediately informs the concerned police station and they bring the charge sheet and file it. So a question arises, what was filed, because it has been explained in the judgment of Kesh Paul and other judgments also, that once the application for default bail has been filed, then an indefeasible right accrues to the accused. It cannot be defeated. So merely because the charge sheet is filed on the same day will not defeat that right. If the charge sheet is being filed after, so even if it is filed 5 minutes after the application, the bail has to be granted. So there were many controversies, and in a recent judgment, our High Court had also issued some guidelines that whenever charge sheet is filed, you have to record the time when the charge sheet was filed, and similarly when the application is filed, you must put the time on the application also, so that whenever this controversy arises, it can be solved. So I was recently asked by somebody, because they are following a procedure that once an application is filed, it is not filed directly in the court. It is put up before the registry, and then it may take some time before it comes to the court. And in the meanwhile, sometimes the charge sheet, the IO comes and he files a charge sheet in the court. And then the magistrate wants to know that the application came to me after the charge sheet had been filed before me. But the question is that the concerned accused, he had filed the application as per the procedure before the registry. And the registry is supposed to put the time on that application. So we have to see that time. So even if the two things are contemporaneous, we have to see which was filed earlier. If the application is earlier, then the bail has to be granted. Then it has to be granted. And we may add to that also something more. Sometimes once the magistrate passes an order that all right, you are admitted to default bail, then the bail bonds have to be furnished by the police. They have to be furnished. Supposing he doesn't furnish the bail bond on that day, and the charge sheet is filed in the meanwhile, and on the next day he says that now I want to file, no, then he will not, then his right gets extinguished. So our High Court in one of the cases has said that it should be a reasonable period, because sometimes it may happen that the order which is pronounced at 4:30 p.m. and after that the court may not be sitting in the court, and so on. So the only option left with the accused is to come on the next day in the morning and file an application. And rather, as per the Supreme Court judgment, they say that the court can even fix a time, reasonable time, that you have to file the bonds within this period. That can also be. If that is not laid down, then some problems arise.
Right, sir. Sir, there is another question. In case an FIR against 4 accused is lodged, and on the 60th date, challan is filed against 3 of them, and it is stated in the paragraph, last part of the challan, that challan against accused number 4 would be filed after completion of investigation against him. So whether the 4th accused is entitled to default bail?
These questions are actually, these questions were received from the field actually. So some of the questions are not clear also. There is vagueness to some of the questions. So in this question, we do not know when the third person or fourth person?
Fourth person.
Fourth accused. When was he actually arrested? Supposing the police, there are 4 accused, and all the 4 accused are being arrested on different dates. and they are being remanded on different dates, the period starts from the first day of remand. So whenever it will be different for each of the accused. Right. So merely because the challan has been filed, maybe the fourth accused has not even been arrested so far. Right. And that is why they have written on the charge sheet that the investigation against him will be continued or conducted whenever he is arrested.
Right. Sir, which days are to be excluded while counting days for default bail under section 167 to CRPC?
Yes. As far as the law stands till date, we have to exclude the first day on which remand is passed by the judicial magistrate. The first day is to be excluded. So on this we have the case of Ravi Prakash versus State of Bihar, 2015, Volume 8, SCC 340. And again, it was the same judgment was referred to and by a three-judge bench in the case of Ravindran versus Intelligence Officer. The citation is 2020 Supreme Court cases, not Supreme Court cases. It is Supreme, some journal by the name of Supreme. Page 627. Page 627. Okay, so we have that. I may add to that. I said that as far as the law stands today, because there is a controversy, there have been some judgments which say that the first day should also be included. On the day when the accused is being remanded, that should also be included. And this matter is now pending before the Chief Justice for constitution of a larger bench, because this was laid down in a three-judge bench. Now a larger bench will have to be constituted because there are conflicting judgments of the Supreme Court on this point.
So next question is also, I think, from the field only. It is, in case the accused surrenders and IO does not turn up in court and does not make arrest, and the court sends the accused in judicial remand. Next day, IO comes up with an application to seek the arrest of the accused. The court issues production warrants for next day, and on appearance of accused in court allows IO to make his arrest. IO was granted police remand for 1 day. Thereafter, the accused is sent in judicial remand. Now the question is, from which date the period of 60 or 90 days has to be computed?
The answer is quite simple to that, though it may look very complex. The answer is on the first day of remand. So on the very first day of remand, when the magistrate sends him to judicial custody, the period starts from that day. Of course, the first day has to be excluded as per the law presently applicable. Merely because subsequently this remand has been given doesn't make any difference to that. So that is also a part of remand. So it starts from the very first day when he sent the accused to judicial custody.
So what is the appropriate forum for cancellation of default bail?
Cancellation of default bail. Can a default bail be cancelled? The answer, we have to answer that question first. Yes, it can be. It can be cancelled. So, do we have different grounds for cancellation of a default bail as compared to regular bail? The answer is no. We do not. The grounds are same. If a default bail is to be got cancelled, the application has to be filed on the same grounds as it is done in the case of regular bail or anticipatory bail. So, so what are the grounds for cancellation of bail normally? There are two types of grounds. One, because the question is pertaining to forum. So there are two situations. In one situation, he will have to file the application in the same court from where the bail was granted, and in the other situation, he will have to go to the superior court. Supposing he's challenging the merits of that case, he says that this order is not as per law, then he has to go to superior court. And if he says that after the concerned person was released on bail, he is misusing the liberty granted to him, or that there are chances of his absconding, or that he is trying to interfere with the investigation or tamper with the witnesses. All those grounds are for filing an application before the same court. Then he goes to the same court and says that this person whom you had released on bail, he is misusing the liberty which was granted to him. So kindly cancel his bail. His bail can be cancelled, but it is not something which can be done very lightly. Once a bail has been granted to a person, then cancellation of bail is not an easy affair. So we have to be very careful when we are going to cancel the bail. We have to act very cautiously.
Yes.
So there are two forms.
Sir, can we apply principles of Ajit Singh versus State of Punjab case in Excise Act cases also?
So Ajit Singh's case, maybe some of the officers may not be aware of what was the Ajit Singh case. Ajit Singh versus State of Punjab. It was a division bench judgment on the question of challan being incomplete. And it was held in that case that if the FSR report is not filed along with the charge sheet, then the charge sheet is incomplete. And once it is incomplete, then in NDPS case also, or any case, then the accused becomes entitled to default bail. So this judgment, what is the importance of this judgment? Because this judgment has been in there has been some criticism also, but I would go with this judgment. I would go with this judgment personally. The criticism is that because there was an earlier judgment of the full bench of our High Court in the State versus Mahal Singh case, wherein they had said that merely non-filing of FSL report doesn't mean that the challan is incomplete. And that was in 1978 judgment. And then earlier to that, we had a Supreme Court judgment in Tara Singh case, wherein also they had laid down law on the similar lines. So now the criticism is that how can you bypass those earlier judgments which were of larger bench and of a superior court? But this judgment, it has discussed both these judgments and has tried to distinguish those judgments. And how it has tried to distinguish, it says that as far as NDPS cases are concerned, this judgment is on NDPS cases. As far as NDPS cases are concerned, if the FSR report is not filed, we cannot say that the challan is complete. It has to be treated as incomplete. Why? Because the provisions of NDPS Act are so stringent, and a person who is taken into custody, the investigation is permitted for 180 days under 167, and even that can be extended up to 1 year on the request of the public prosecutor. So that person can be kept in custody during investigation for 1 year. And thereafter, the provision for bail under section 37 is very stringent. It's almost impossible to get a bail under NDPS Act if we follow the provisions of section 37. So once, supposing the IO, we can't say that IO is an expert in every case. He gets some information that some narcotic substance, the concerned person is having some narcotic substance. So he arrests that person and takes that substance into custody, and he agrees that it is a narcotic substance. Though he's no expert in that field, he may be wrong. He may be wrong. And now it is being compared with Excise Act. Why the same thing is permitted in excise cases and not in here? In excise cases, the matter is much simpler. The people are trained to test whether the lahan or the country liquor which is being seized by taste and by smell, they can tell that whether it is lahan or country liquor, etc. But that the matter in NDPS cases is not that simple. And moreover, and as far as excise cases are concerned, their bail is normally granted in those cases. There is no such stringent provision. So in NDPS case, you can keep that person for 1 year and deny him bail because the investigation is pending. And thereafter, the police files it. On the last day, they file the charge sheet without FSL report. And still, if the court says that the challan is complete and the investigating agency takes another 6-7 months for filing of that FSL report, so that poor man is being kept in custody for more than 1.5 years, and thereafter if the report comes that no, there was no narcotic substance in the contraband which was seized, then I think it is imaginable that what we have done to that person. So on that footing, the court says that as far as NDPS cases are concerned, FSR report is a must. It should be there, otherwise the challan is incomplete.
Sir, if the accused who is on anticipatory bail has appeared in the court and furnished bail bonds, so whether court will take fresh bail bond after filing of charge sheet?
No, why should they? Why should they? Once and on anticipatory bail, then the confusion is on account of the earlier judgment in the case of Salahuddin, where a 3-judge bench of the Supreme Court had laid down that anticipatory bail is to be granted only till the filing of challan, and thereafter only a regular bail application can be decided and the person can be released. You can't release a person on anticipatory bail beyond the period, beyond the filing of charge. That was not the correct view, and this has now already been settled in the case of Sushila Agarwal also. Sushila Agarwal Constitution Bench has already settled that. So once he is granted anticipatory bail, normally it goes till the end of the trial. Okay, fine, that is true. So once if he has appeared in the court, he has filed the bond, then why would we ask him to file the bonds again when the challan is filed? It doesn't make any sense.
Sir, now in this case, if during the trial accused absents and his arrest warrants were issued, now can the accused claim the benefit of Sushila Agarwal case by taking the plea that he was once granted anticipatory bail before filing of challan and now it remains operative till the end of the trial? So he should not be arrested and even after jumping bail?
No, it cannot be done. Sushila Agarwal case doesn't talk of anything of that sort. If you grant bail to any person, whether it's regular bail or anticipatory bail, there is a condition in that. You have to furnish bonds as per I think it's section 440 or which stipulates that it must contain a condition that he will appear on each and every day.
Yes.
If he doesn't appear, then the bonds are forfeited.
Yes.
Okay. So if the bonds are forfeited, then we have now this provision under section 446A. New amended provision is there. Once the bonds are forfeited, then the bail bonds stand cancelled. So earlier, some clever lawyers, they always used to come forward with this argument, because the bail has been granted by a superior court and the accused absents. That doesn't mean the court cannot pass an order that the bail of the accused is being cancelled. The junior court cannot cancel the bail granted by a superior court. So this was the argument, and on that basis, this is a continuation of that. So they say that he will remain on bail, but as far as the bonds are concerned, because the bonds have been forfeited, he can furnish fresh bonds. Now that argument is not available to them because of section 446A. 446A has made it clear that once the bonds are forfeited, then the bonds stand cancelled, and thereafter the magistrate may admit him to fresh bail. The words are may. May means he may or he may not. So the discretion has now been given to the magistrate, and it may be an order passed by any court. It may be High Court or the Supreme Court, any superior court. It applies to all. So Sheila Agarwal case will not stay.
So next question is, an accused is on anticipatory bail from Honorable Supreme Court. Now challan presented in the court. Court notices are being sent to accused to appear, but he's avoiding service. So what should be done in such circumstances? Can the court issue a non-bailable warrant?
No. We have this provision in 438, clause 3, which tells us that in such circumstances, if you have to issue a process, you may issue a bailable warrant, not a non-bailable warrant. Bailable warrant can be issued in consonance with the directions which have been given for releasing him on bail whenever he is arrested. So only a bailable warrant can be issued, but does that solve the problem? The problem which the officer is facing is now what to do. Supposing he doesn't turn up even on bailable warrant, then what is to be done? So if he doesn't turn up on bailable warrants, then he can go and issue a proclamation under section 82. That is permitted. Once a warrant has been issued, it may be bailable, it may be non-bailable, and he doesn't turn up, and you have a report that the person concerned is concealing his presence or he is absconding, then proceeding under section 82 can be initiated. And moreover, the state can go and file an application before the same court which granted bail that his bail should be cancelled. This person is not turning up. So his bail can also be cancelled, and proceeding under section 82 can also be initiated against him.
Sir, if after release of the accused on anticipatory bail,
I think this is the same question. It's on the same question. Go on to the next one.
So next question is whether regular bail can be granted by a magistrate if anticipatory bail is not granted by Honorable High Court or Supreme Court, and the petition for anticipatory bail is disposed of and nothing is pending there.
So anticipatory bail was filed by a person and it was disposed of by the High Court. He was not granted bail. Okay. So final order has been passed. Now the person comes to the trial court and wants to file an application for regular bail. So he can do that only if he has some fresh grounds. If the application for anticipatory bail was filed on, say, grounds A, B, C, so he cannot come to the trial court and file the application for regular bail on the same ground. But if he has a fresh ground, then he may file it. Because we have the decision of the superior court on those three grounds. So we cannot bypass that decision. So only if there is some fresh ground, he can file it.
Sir, if the accused is on bail and during trial it was found that the case ought to be committed under section 323 CRPC, can the accused be given opportunity to file anticipatory bail to get bail for the offence after informing him that the case will be committed on a particular date, or that he is to be arrested on the date of pronouncement of order without giving opportunity?
So if you want to commit the accused under section 323, so the accused is taken by surprise sometimes. He is taken by surprise sometimes. He doesn't know that what order is going to be passed by the court, whether he is going to commit the case or it is not going to commit the case. But there is no provision in CRPC which can help the accused in that regard. So the order has to, we have to go by CRPC. So if you pass an order, and if you are able to grant, if the concerned court is able to grant him bail, well, it can be done. But if the court is not competent to grant bail, then he has to be taken into custody. There is no such provision that we can afford some time to him so that he may approach the superior court and obtain bail from there. No, we cannot do
So can Session Court grant anticipatory transit bail in cases where offence is committed in Delhi and arrest is apprehended in Punjab?
Transit bail actually the word is not correct. Actually what is being done is that we are granting him bail for a limited period. Say we grant him bail for 15 days with the object that he may approach the concerned court and file an application for anticipatory. Now the offence has taken place at Delhi and the person may be residing at Chandigarh, and he says that the cause of action has arisen at Chandigarh. I am apprehending arrest at Chandigarh, so I am entitled to file an application at Chandigarh. The view on this regarding territorial jurisdiction, there are different views. The different high courts have different views. As far as our high court is concerned, our high court's view is that the application will lie where the offence was committed. If the offence was committed at Delhi, then the application lies at Delhi and not at Chandigarh. That is the view. There are two judgments of the High Court on this. They are 1984 Criminal Law Journal, page 714, and 1994 Criminal Law Journal, page 3134. In both these judgments, our Honorable High Court has clarified, because the word 438, what does 438 say? 438 says that if a person is apprehending arrest, he may file an application before the High Court or the Court of Session, seeking a direction that he should, in the event of arrest, he should be released on bail. So the word is High Court or Session Court. Now the question is which High Court and which Session Court. So our High Court in both these judgments say that the word High Court and Session Court mean the within the territorial jurisdiction of which the offence was committed. But now most of us will say that well, transit anticipatory bails are being granted. Yes, they are being granted, but the High Court has inherent powers under 482. As far as 438 is concerned, our High Court has taken a view that no, it lies where the offence took place. So it should not be passed under 438, but under inherent power 482, they can pass as an order. But as far as Session Court is concerned, it doesn't have any such power. It doesn't have the inherent powers, so it will not be able to pass any order. If we are to interpret it in the other way, other sense, then supposing a person commits an offence at Chandigarh and we read the word Session Court as any Session Court, then he can go to Guwahati Session Court somewhere or Kerala Session Court. So we have thousands of Session Courts. So that means he can go to any Session Court and file an application. So we can't have that interpretation. We can't have that.
So is it legal to grant regular bail on the basis of interim bail granted by the Superior Court under Section 438 CRPC? In case accused on the basis of interim bail order demands bail from trial court, what is to be done?
Yes, this has been. We had some cases, and the Supreme Court had to circulate those judgments. One of the cases was Satpal Singh versus State of Punjab, and another was Rukmani Mahato versus Rukmani Mahato, 2018, Volume 2 RCR, page 817. So what happens is that a person goes to the Supreme Court and files an application for anticipatory bail. He is granted an interim order, interim bail, and then he comes and files that order in the trial court and says, look here, I have been granted this interim bail by the Supreme Court, so kindly grant me regular bail in this case. Well, can he do that? No, he cannot do that. How can he do that? because the application which was filed before the Supreme Court is still pending. The Supreme Court has not decided that application for anticipatory bail. It has only passed an interim order. It has only passed an interim order that during pendency of anticipatory bail application, he shall remain on bail. So that matter is still sub judice before the superior court. So the subordinate court cannot ask an order for regular bail on the basis of interim order asked by the superior court.
So when a person gets interim bail under section 438 CRPC from Honorable High Court, and on its basis he gets regular bail from the trial court. However, the anticipatory bail application is dismissed on final hearing by the High Court. Whether regular bail given by the trial court will be automatically cancelled?
See, we talked about the case of Pal Singh, state of Punjab. In that case, one of the accused had managed to obtain anticipatory bail. The second one tried, but he was not granted, so he went to the Supreme Court, and then the matter was looked into, and they found that the bail was wrongly granted to the first accused. It was an NDPS Act case. So they cancelled his bail. But once you have granted regular bail, supposing the trial court has granted regular bail, it will not automatically get cancelled. It has to be got cancelled from this period. The trial court will not be able to cancel this. They will have to go.
So accused is on interim anticipatory bail granted by higher court. Meanwhile, challan is presented before the trial court. At the time of filing of challan, the accused moves in application for bail. The bail application has to be decided preferably within 7 days. But the next date of hearing before the higher court is longer. So how to proceed in such a case?
So look, it looks a complex question, but actually
being faced by the trial courts.
So what happens is that on the basis of an interim order, we have already discussed that you can't get regular bail from the trial court. So this person, he comes on the basis of interim order and makes a request to the court that I should be granted regular bail. Now the concerned officer who has sent this question, he has some confusion that we have a judgment of the Supreme Court Chandigarh case where they have issued a guideline that the bail applications have to be decided within 7 days. So he says that application before the superior court is still pending. What do I do with this? What you have to do with it? You have to dismiss it. That is simple. You have to say that on the basis of interim order, I cannot grant you regular bail. You can dismiss it on the very same day. You don't have to wait for 7 days or wait for a month or so. So it can be dismissed straight away.
So can accused file successive anticipatory bail application? And if
Yes,
yes, on what grounds?
Yes. Actually, legally there is no bar. Legally there is no bar. You can file as many applications, but every application has to be on a fresh ground. You can't file a second application on the same ground. Only on the fresh ground you can file a second application. So that is perfect. This was laid down as far back as 1978 in a judgment by Justice Krishna Iyer, Bhangoo case, Bhangoo versus State of Chandigarh.
Sir, in the case, the application of the accused filed under section 438 CRPC was dismissed by the High Court, and petitioner was directed to appear before the trial court, which in this case is the Court of Additional Sessions Judge. He applied for regular bail and filed an application under section 439 CRPC. Can he also make an application for interim bail pending disposal of the regular bail application?
That is the question. That is what he is asking, is that during pendency of regular bail application, can you get interim bail? Yes, the answer is yes. Even under an application filed under 439 CRPC or 437 CRPC, you can also make a request for interim bail. So we have judgments of Supreme Court on that. One is Mukesh versus State of West Bengal, 2010, Volume 15, Supreme Court Cases 154. And another one is Sukhwant Singh versus State of Punjab, 2009, Volume 7, Supreme Court Cases, page 559. 559. So there is a provision. There is a provision for, though we don't see much of that. Most of the officers are not even aware of it, that there is a provision where interim bail can be granted. It is similar to that provision under section 125. 125 never talked of interim maintenance. So it was Supreme Court which interpreted it. Once you can grant maintenance, you can also grant interim maintenance. Similarly, here you can decide an application for bail, you can pass an order for interim bail also.
So, sir, what may be the grounds on which this interim bail may be granted?
So, grounds, first of all, the person should not be in custody. Because that is the purpose behind it. Supposing he had gone to the superior court and they refused to grant him bail and they told him go to the trial court, and he comes to the trial court and surrenders before the trial court and files an application. So he's not in custody. And remaining grounds are the same. We see the gravity of the offence, we see his status, we see his age, chances of responding, chances of tampering with witnesses. Those are the things which are considered during that short period. Supposing he is granted interim bail for 1 or 2 days, so during that period we want to be sure that he will not be able to misuse that bail or evade justice in any form. There may be a case where the police has carried out the investigation and they felt no need for arresting the accused. And now that person comes and appears in the court and he files an application for regular bail. So once you see that the police never felt the need for arresting him and he has not in any way misused that concession. So why not to permit him to stay on bail even during the pendency of the regular bail application also? That makes sense. So those are the things which we consider.
Right. So there's a situation, suppose one accused files a regular bail application which is dismissed by ASJ and Honorable High Court grants bail to another co-accused. So whether this person whose regular bail was dismissed by the session court can file second application for regular bail on the basis of parity before the session court?
Yes, he can file, of course he can file, but the question is how do we define parity?
Seems.
We have to see parity. There are 4 accused in a case. We cannot say that they are all on parity with each other. They have all a different role to play. They may be of different ages. They may be from different backgrounds. One of them may be a habitual offender. Another may be a very respectable man. So parity has to be seen from all those angles. So merely, but if the facts are similar as far both the accused are concerned, then of course he can file an application. He can make a request because the other accused has been granted bail, so I should also be released from bail.
Next case is also somewhat similar. Next question. In case under section 302 IPC, bail was declined by ASJ on merits, and after 15 days, bail application of co-accused on similar allegations is allowed by the Honorable High Court. Will it be justified to again consider afresh the bail application and allow bail on parity?
Well, here, I think we have already answered.
So next question is whether it would be advisable to take an affidavit of both the accused or counsel to apprise the court regarding the pendency or final disposal of bail application filed before any other competent court.
Yes, we have one judgment of our High Court that was in Vijay Kumar versus State of Punjab. Vijay Kumar versus State of Punjab decided on 22nd July 2021, where they have issued guidelines that the application filed by the concerned person must have a para disclosing that whether he has filed any application, other application, and what was the date of that application. That has to be there. And then the same judgment lays down burden on the prosecution also, that in every case the prosecution has to inform the court whatever material they have, whether any previous application was decided in this case or not. And if they conceal that fact, then it will be considered as a fraud on the court. Then it will be a fraud on the court. So that is a necessity. It has to be. It must be followed. It must be followed. It should be done.
So to what extent the merits of the case can be considered while deciding the bail application?
Merits. We have to go through the merits of the case, but there cannot be any critical analysis. There cannot be any critical analysis of the evidence. We take the things as they are on the face of it. On the face of it. We don't go deep into it, deep into the evidence. We don't try to critically analyze that evidence. We only see if the ingredients on the very face of it. We don't go into it, whether the ingredients are laid out or not. That can be seen. But we don't analyze that as if we are going to pass a judgment in that case, final judgment. That is not.
So can a magistrate grant bail under an offence under section 326 IPC, which entails maximum punishment of life imprisonment?
Yes. That is an important question, because all along we have been hearing this, that no magistrate cannot grant a bail under section 326 because it carries a sentence of life imprisonment. That was a wrong notion. Actually, the law, basic law is that if a magistrate can try a case, then he can always decide application in that case, always. If he cannot try that case, then only if the statute permits him, otherwise he cannot. So as far as 326 cases are concerned, though the maximum punishment is 326, but it is triable by a magistrate. So he can try that case, he can convict the person. So why not bail? Now we had one judgment earlier of Justice Amarnath, which was Ramji. We have this judgment of Chandra Kumar, same judgment, Chandra versus CBI, where they have explained this, that if the magistrate has the jurisdiction to try the case, then he can decide the bail application. So 326, 409, all those cases having life imprisonment, the bail application can be accepted.
So the next question is related to 409 IPC only. It says Challan has been filed under section 406, 409. Accused was not arrested by the police during investigation. Now accused moves regular bail application claiming bail on the ground that investigation has already been completed. So how to deal with such bail application as section 409 is punishable with imprisonment for life?
Same answer. We have already answered. वही है 326 में वही है 409 में वो सिचुएशन है ट्रैवल बाय मैजिस्ट्रेट है तो लाइफ इम्प्रिजनमेंट से कोई फर्क नहीं.
But sir, here the peculiar factors, he is claiming bail on the ground that investigation has already been completed. So sir, next question is, sometimes police wrongly add section 467 IPC in remand papers just to enhance the gravity of the offence. At the time of dealing bail application, whether finding of no cases made out for section 467 can be given?
Yes, it can be. As we said that we cannot critically analyze the evidence, but we can look at the entire material produced by them on the very face of it. If the ingredients are not made out, we can put that in black and white also. That on perusal of the material, we do not find the ingredient of section 467 being made out.
So what if the police add one of the offence which is triable by the Court of Sessions and which is prima facie not attractive to the facts? Right. See, I think same will apply.
Yes.
So next question is, accused is granted bail for offences under section 324, 325 IPC. Subsequently, investigating officer arrested the accused for offence under section 326 IPC without permission of court and produced him before the court with the request to send him to judicial custody. Should he be released on bail or sent to judicial custody?
So, this pertains to rearrest of a person. Firstly, they have filed a charge sheet under section 324, 325. Now they have added an offence under section 326 and they want to rearrest that person. So can they make the rearrest, or they are required to follow some procedure for that? This has been clarified by the Supreme Court in the case of Pradeep Ram versus State of Jharkhand, 2019. Supreme Court cases online, page 825. So in such like cases where some offence is added to the charge sheet and the police want to arrest him, it is true that now as far as 326 is concerned, he is not on bail for that offence. So he cannot say that because I have been granted bail under section 324 and 325, so any addition will not, to the charge sheet will not make any difference. It will make a difference because we have to hold that he is not on bail under section 326. But the law says that once he has been granted bail, then the police cannot arrest him by themselves. They have to go to the court. They have to file an application before the court that they want to arrest him, and they make a prayer that a warrant may be issued. They may seek a warrant from the court, or they may even seek cancellation of the bail. That request can be made. In Pradeep Ram case, they have put forward three eventualities. They say that the concerned accused, he can by himself, once he learns that some additional charge has been framed, additional offence has been added to the charge sheet, he may go to the court concerned and file an application for bail, that you have already granted bail to me under 324, 325, kindly grant me bail for offence under 326 also, which has now been added by the police. So if that request is accepted, then fine. If it is not accepted, then he can be arrested. Okay. Or if it comes to the knowledge of the court that 326 has now been added, then the court has to take him into custody, or if it is competent to grant bail, it can grant bail to that concerned person under 326, or it can even cancel the bail. But there is no necessity of cancelling the bail already granted under 324, 325. They can only say that 326 is added, he is not on bail in 326, and we are not in a position to grant him bail for that offence, so he is taken into custody, or he can be taken. But as far as the police is concerned, if they want to arrest him, they have to go to the court. They have to go to the court. They cannot arrest, which they were doing earlier. They cannot do that. Now he says, supposing he has been arrested, then what happens? So if he has been arrested and produced by the court, then the court has to release him on bail. This is what the Supreme Court says. Supreme Court indicates that there was a case under Manoj Suresh versus State of Maharashtra, 2019, volume 17, Supreme Court cases, page 362. In that case, the concerned accused was charged for offence under section 509, and he obtained bail for that offence. Subsequently, they added offence under section 376 and arrested him and produced him in the court. The Supreme Court says that he should have been released on bail, and they passed an order that he is being released on bail as far as suspension. He is being released on bail on the same terms as pertain to the earlier order, and they also added that if the state can file an application for cancellation of it. That is permitted, but once he has to be released on bail because he has been wrongly taken into custody, so he will be released on bail, and if the state wants, they can file an application for cancellation.
Right. So whether one and the same person can be allowed to stand surety in more than one case?
Yes. I think we have been doing that in some cases. There is actually what has to be seen is that supposing a surety, what is the property owned by the surety? What are the offences? If he has sufficient property which can cover both the cases, then there is no bar. And if he is otherwise found reliable also, in all respects, if the court is satisfied from his conduct also, there is no such legal bar that you can't take him as surety in a second case. You can take him as a surety. If the other conditions are fulfilled.
Right. So far as section 389(3) CRPC is concerned, if accused is convicted and sentenced to imprisonment for more than 3 years, whether such convict can be released on bail under section 389 subsection 3 CRPC?
389(3). में there can be a situation, supposing he is held guilty for 2 offences and he is given a sentence of say 3 years and 1 year. 324, 325, let's take a case of 324, 325. 3 साल और 1 साल सजा कर दी और कंजेक्टिव कर दिया उसको. कंजेक्टिव कर दिया तो उसका मतलब 4 साल होगी. अब 3 साल से ऊपर होगी तो क्या उसकी बेल हो सकती है 389(3) में? The answer is yes, because both the offences are available. उसमें ये 2 चीजें हैं. अगर offense जिसमें उसकी कन्विक्शन हुई अगर वो अवेलेबल है तो 3 से ऊपर हो जाने से कोई फर्क नहीं पड़ता. पर अगर वो नॉन अवेलेबल offences हैं तो फिर वो 3 से ऊपर नहीं होगी, फिर 3 से ऊपर होगी फिर नहीं होगी. Then it will not be. So that is the criteria 389(3).
Yes. So next question is, charge sheet was filed against 2 accused. The court took cognizance. Thereafter, the 3rd accused was arrested and the police filed an application seeking police remand of 3rd accused under section 167 CRPC.
पानी में भी गरम ठीक. That's an interesting question. Now we have charge sheet has already been filed against 2 accused. Charge sheet has already been filed, so the court has taken cognizance. Once the court has taken cognizance, can the provisions of section 167 still be enforced against the 3rd accused who is arrested thereafter? Can the person be handed over in police custody under 167? And the answer to this has been given by the Supreme Court in the case of CBI versus Dawood Ibrahim, a 3 judges bench case. 2000, volume 10, Supreme Court cases, page 438. The answer is yes, court can. Even after the question was whether the provisions of 309 will have to be utilized or 167. They say 167 also can be applied and police remand can be granted against the 3rd accused who was arrested after the court had taken cognizance of the offence.
Sir, is there any provision in CRPC whereby bail can be granted to a person who is not accused of any offence?
Person who is not accused of any offence, whether bail can be granted to him under CRPC? The answer is yes, it can be granted. Any example? Yes. Say 151 CRPC. 151 CRPC is not an offence. It's just an apprehension of breach of peace. So all those cases, they are not offences, but bail can be granted. If you read section 436, it doesn't say that some offence should have been committed. 437 को ध्यान से पढ़ो, इसमें ये नहीं है. तो 437 में है, ठीक है, कमीशन ऑफ ए नॉन बेलेबल ऑफेंस, उसमें है. 436 में ऐसा कुछ नहीं है. तो जो ऑफेंस ऐसे हैं जिसमें ऑफेंस नहीं किया उसमें ही बेल करके एप्लीकेशन आ सकती है. तो 436 में उसकी बेल हो सकती है.
Sir, is there any provision in CRPC whereby a court which does not have jurisdiction to try the case can grant bail to the accused in such case?
अभी हमने यही कहा था, we just had this, कि जिसमें jurisdiction है कोर्ट को उस केस में वो बेल कर सकता है. अगर वो he can try the case, he can grant bail also. और इसका वाइस वर्सा है. अगर किसी केस में उसको jurisdiction नहीं है तो क्या वो बेल कर सकता है? तो वो उसमें स्टैट्यूट में ही जाना पड़ेगा ना. एक प्रोविजन तो सेक्शन 81 है, एक प्रोविजन तो सेक्शन 81 ही है जिसमें उसको jurisdiction नहीं होती. It doesn't have jurisdiction and still he can grant. CGM और सेशन कोर्ट को पावर दी हुई है सेक्शन 81 में. They can grant bail to a person जिसको beyond territorial आपकी jurisdiction के बाहर आपने वारंट भेजा है किसी आदमी को अरेस्ट करने के लिए, तो वहाँ पर वो जब उसको पेश करते हैं तो अगर वो बेल एप्लीकेशन सीजीएम या सेशन जज के पास लगा सकता है वो एप्लीकेशन, और वो उसको बेल लिमिटेड पीरियड के लिए देते हैं. वो ट्रांजिट बेल है, वो ट्रांजिट बेल है, वो ट्रांजिट बेल दी जाती है कि आप जब उस कोर्ट में पेश होंगे उस पीरियड के लिए बेल दी जाती है. दे डू नॉट हैव जुरिसडिक्शन टू ट्राई द केस. 81 है ना भी इंस्टेंसेस.
So can the officer in charge of a police station grant bail to any person accused of the commission of non-bailable offence who is arrested or detained without a warrant?
437 में पुलिस को भी पावर है बेल करने की, कर सकते हैं. पर एक चीज है उसमें, जैसे the cases which are covered by the वो 16 साल की एज वाला और विमेन वाला, वो जो पावर है वो सिर्फ कोर्ट के पास है, वो उनके पास नहीं है. बाकी ऑफेंसेस में कर सकते हैं, पर जहाँ भी बेल अगर पुलिस वाला करेगा, कोई भी करे, तो उसमें आगे उसी 437 में लिखा हुआ है कि उसको ही हैज टू पास ए रीजन ऑर्डर पास करना पड़ता है, उसको रीजनिंग देनी पड़ती है कि क्यों मैंने बेल किया है, इसलिए नहीं करते हो. ये भी प्रॉब्लम होती है. पावर तो है.
So can gravity and seriousness of alleged offence be the basis for refusing regular bail?
अब ये बेसिस वाली बात है ना. Can they be the basis for refusing bail? तो they cannot be the basis. बेसिस में तो सारी चीजें देखनी पड़ती हैं. किसी को 302 के केस में भी बेल मिल सकती है, हालांकि ऑफेंस तो बहुत ग्रेव है. सीरियसनेस ऑफ द ऑफेंस इज नॉट इन डाउट, पर ये मतलब 304 बीम में मिलती है, 307 में भी मिलती है. तो मियरली ग्रेविटी उससे नहीं, सारी चीजें देखनी पड़ती हैं. तो ये खाली ये बेसिस नहीं हो सकता. तो बेसिस तो सारी चीजें. तो वो मेरे ख्याल हमने जितने क्वेश्चन थे उनके आंसर अपनी तरफ से कोशिश की है देने के लिए. तो इसके बाद भी अगर किसी को कोई क्वेरी रह जाएगी तो ही कैन एड्रेस दैट क्वेरी टू मी अगर करना चाहें तो ऑन माई ईमेल आईडी विच इज harinder@gmail.com. harinder@gmail.com. आप क्वेश्चन भेजना चाहें कोई भेज सकते हैं, या इस वेबिनार के मतलब कोई क्वेश्चन अगर आपने पूछना हो. तो नेक्स्ट.
Sir, I, on behalf of all the officers, express my deep gratitude towards sir for giving us deep insight into this topic. Thank you, sir.
Thank you very much, Karan.